Hello everybody and welcome to the first lesson in a particularly long series on the history of English law. Now I'm very excited to be doing this series of lessons now, and essentially what's going to happen is very similar to the criminal justice system lesson that I released earlier today. This video is going to be an introduction to the history of English law. We will explore what we're talking about, we'll explore the importance, we'll talk about the complexity, we'll outline the scope of this series of videos, and then talk about some citations and further reading at the end. And really this is going to be an introduction that is released today in the sort of middle of October, in preparation for a whole series of these lessons coming out weekly in the new year, starting in January 2025. Just as with all of the other videos that are already currently being released, if you are a level 2 or above member, you have access to these lessons as and when they are put onto the YouTube channel, regardless of whether or not they release later on in the year or not. So that's essentially the introductions out of the way. This lesson specifically, as I said, is going to outline the scope of this set of lessons while taking an introduction to the subject of English legal history. And then we will talk about some of the main readings and further readings for this series of videos as well. So let's begin then. Let's begin with this. And let's think about the English legal system as from a historical perspective, and think about the history of English legal system, the English legal system, or the history of English legal history. This is sort of like a meta-historical study, if you will. Generally speaking, most historically significant parts of English law as we know it today, in terms of their historical development, develops out of the common law, okay, or at least forms as a part of the common law. This is why, for the most part, or at least for the first half of this series of lessons, when we look at this really early history, we will be concerning ourselves almost exclusively with the development of the common law and the history of the common law as it develops through time. We will get on to talking about the increased role of Parliament, the nature of the Constitution, and the various different constitutional changes that starts to develop as well, as we get closer and closer to the present day. This is going to be a history of English law starting really from the Roman period all the way through the Anglo-Saxons, the Norman Conquest, Henry II, all the way through to the Tudors, all the way past the Tudors to the Stuarts and the constitutional revolution that takes place there, all the way to the present day. We're going to finish, in fact, this series of lessons by talking about constitutional reform that has taken place since 1997 with the Labour governments of Tony Blair and Gordon Brown. We might even go a bit further and talk about Brexit and sort of finish at that point. We'll have to eventually stop, because otherwise we'll just it goes from being a history of English law to just a news channel about what's happening in at the current present time in legal history. So it's going to be a long series of lessons. We're going to be charting what is a good 1,000+ year history, and generally speaking, the history of the common law has a particularly long, rich, and complex development. Okay, its development begins officially, where we can say, right, the common law begins in the sort of Angevin Empire of Henry II. But its procedures and the sort of antecedents of the common law can date as far back as the Roman traditions of the Roman law, when the Romans had taken control of Britain. So we are really talking about quite a long development in terms of its history. The common law itself, if you just want to have a definition for those of us who are beginning this lesson without thinking about constitutional law or thinking about public and administrative law, at the moment, the common law is just the body of law that has evolved through judicial decisions, through legal precedents, and this is obviously in contrast to statute law, where we have a piece of legislation that is created. We will get, as time goes on, to looking at statute law in more detail, because essentially as the common law develops, we sort of see quite a strong emphasis on the common law system and the way in which the common law develops over time. But then as time goes on and a number of important events takes place, the Tudor dynasty is a very important event which takes place, specifically people like Henry VIII were quite important important. But then most importantly, we have, of course, the reign of the Stuart dynasty with James I and Charles I, and we have the sort of overthrowing of monarchy, the establishment of a protectorate, and then we have the restoration of the monarchy, all of which culminating in the growth and power of importance of Parliament. And of course, Parliament begins to grow as time goes on. And then we start to develop from there constitutional principles. Even though we are going to be talking about Magna Carta from 1215, and we'll talk about other things that develop in terms of our constitutional history, the way in which we speak about the Constitution as we know it today starts to develop after the sort of Stuart period, if you will. There are points that happened before, but this is the sort of point at which we see the Glorious Revolution. We see the sovereignty of Parliament be well and truly codified. And then we start to see more development as time goes on. And I'll talk about that in a minute when we look at the structure of this series of lessons. One of the reasons why the history of English law is so important, is such an important thing to study, is not just because of your understanding of the English legal system as it exists in England and Wales today, which is, I think, a very important thing for you to study. If you're somebody who wants to practice law in the future, there are sort of two modules that I would always recommend anybody do at university studying law that aren't directly to do with the sort of doctrinal legal principles in commercial law or company law or family law or whatever. And that's firstly the history of English law. So you see a development of this sort of historical development from of the system that you are studying and living in at the moment, but also jurisprudence. I think legal philosophy or legal theory is also quite important. But not just because of that is the reason why the history of the English legal system is important, but so too is it important because it forms the foundation of legal systems in a great number of countries. One of the things that we did as part of the British Empire was export a number of these principles, export the ideas of precedent and the common law and all of these different things. And that's why some of the legal systems that we see in the Commonwealth or former colonies of the British Empire have similar traditions and have similar systems. And so these ideas aren't just unique to England and Wales. They are expanded and extended across the entire world. And so that's something that also needs to be taken into consideration when thinking about the history of the English legal system. So we know that there are various different sort of inflection points in the history of the English legal system that really does lead to a quite major radical development in one direction or another. So you have, of course, the Roman occupation of Britain. You then have the Anglo-Saxon legal system that begins to develop, and then a huge inflection point is the Norman conquests in 1066, which sees the development of a legal system into something known as feudalism. You also see things like the development of the common law under Henry II. You obviously have things like the Magna Carta. You then have things like the Tudor dynasty, like I've said, and then the Glorious Revolution. All of these are sort of major inflection points that sees the legal system shift and go towards one way or another. Okay. So at the time, before the Norman conquest of 1066, you see that the legal landscape was very fragmented. You have what was known as the heptarchy in the Anglo-Saxon period. So a number of quite small systems of governance among Britain, including Wessex, Northumbria, Mercia. You also had Danelaw as the result of the Viking conquests of Britain at various different stages. And within all of this sort of melting pot of different legal landscapes, we see the development of customary laws, which would vary from region to region and in terms of their application. So this is really what we're not even starting at this point here. We're not even starting at the Anglo-Saxon period. We're going to start even further than that by talking about the influence of the Roman law and the influence of the Romans being a part of Britain and a part of our history. So that is the first of the two pre-Norman conquest legal traditions that we're going to explore. And then the second of those is the Anglo-Saxon legal system. The legal system of people like Alfred the Great, people like Ethelred the Unready. People like, for example, King Canute will be explored. Edward the Elder, and all of these different individuals. And this is really even before England, as we know it today, even existed. Okay, you would argue that it was King Athelstan that was the person who formally unified the heptarchy into the English into the system of the country of England that we sort of know of today. So prior to that, we're not even talking about England at this point. Okay, and that just goes to show the way in which law develops over time. That in this kind of way, the law is older than the country in which the law comes from, if you will, or governs. So that's a quite interesting little unique feature of the English legal system. We'll then talk about the Norman conquest, the development of feudalism, and the sort of the ways in which the legal system existed at that point, the criminal law, property law, the way in which inheritance operated at that point, and then we will talk about the development of the common law under the reign of Henry II. So at this point, we're in the sort of 1150 to 1189, and then we will talk about 1215 and the Magna Carta, the sort of influence of Magna Carta, what Magna Carta signifies, okay, in terms of the relationship between royalty and the rest of us, essentially, in the nobility. And then we will move on to sort of the more broader themes. So there's quite a big gap here that we're talking about up to 1500s, which we'll talk about in sort of broad strokes: the development and expansion of the common law into the 16th century, the creation of the Court of Chancery, the sort of dual structure of legal adjudication with a sort of court of equity on the one hand and the legal system on the other, the ways in which equity starts to develop as well over time. There'll be some nice linkages from that to our equity and trust lessons that we've done in the past. And then we're going to start to think about Parliament. Okay, so throughout this entire time, okay, Parliament is sort of under the in the background developing. Okay, Parliament develops from around the 1300s onwards, if you will, and we only really see the major growth of Parliament sort of in response to and in relation to the Tudor dynasty, and then specifically in relation to the Stuarts, specifically Charles I and the relationship, and James I, in fact, the relationship between those two monarchs and Parliament. We'll talk about the modern common law. We'll talk about the Judicature Acts and the fusion debates between equity and the legal system. We'll talk about a little bit internationally, talking about the colonial influence and the exporting of the English legal system. And then we will finally finish on looking at the common law as we know it today. Like I said, going all the way up to the development of the Constitution, up to the end of the new Labour governments in sort of 2000 and 2010. So that's really as high as we're going. And so, with this in mind, let's think about the citations of further reading. So there are a couple of really good sources that we can think about here. You've got J. Baker's Introduction to English Legal History from 2019, one of the best in terms of your sort of early history, sort of medieval common law studies, is The Formation of the English Common Law from J. Hudson. And then you also have one of the main citations for this set of reading, which is a recent book that came out in 2020 titled Law, Liberty and the Constitution, A Brief History of the Common Law. Now, what's very interesting here is the H. Potter, who is the author of this book. The H actually stands for Harry. So if you choose this particular piece of study, you will be studying English legal history from someone called Harry Potter, which I think is particularly good. So I hope you enjoyed this video, and I hope I see everybody in the next lesson for when we talk about some of the Roman traditions and the development of the Roman law in English legal history. So bye for now. Hello everybody, and welcome back to our studies in the history of English law. This lesson is going to talk about the first of the two sort of pre-Norman conquest areas that I want to explore when thinking about the history of English law. The first of these is, of course, looking at the influence of Roman Britain and the Roman law and what the Romans brought essentially to the English legal system. And then the second of those will concern itself with the development of law under the Anglo-Saxons and through the Anglo-Saxon period. So this lesson is going to be the first of, I think, 3 or 4 lessons looking at the history of the English legal system beginning with Roman law and looking at the Roman influence on the English legal system. I believe it's about 3 or 4 lessons. Yeah, about 2 or 3 lessons looking at the influence of Rome and Britain. And essentially what we're going to do is look a little bit at the historical foundations of the English legal system prior to the Norman conquest, beginning with this idea of the Roman law. And remember, this first half of lessons is going to be concerning. We're going to be concerning ourselves almost exclusively with the development of the common law, because the development of the common law sort of takes some foundations in the Roman period, and then more importantly in the Anglo-Saxon period, and then as time goes on through the Norman conquests, and then eventually when we get to the sort of Angevin Empire, we get to see the development of the common law more succinctly. And then as time goes on, we will start to think about the influence and the role of Parliament as Parliament starts to develop and take on a greater and greater role within the English legal system. This lesson is going to explore the historical context of Roman Britain. We'll talk about the specific legal traditions that the Roman law influences over the next couple of lessons. We'll talk a little bit about the Roman law in this video as well. But I want to begin by just talking about Roman Britain. Okay, Roman Britain from around 43 AD to 410 AD was really where we start to see the first influences on the common law. Okay, the Roman influence on the development of the common law is subject to quite a lot of interesting interest and insight, specifically when we're thinking about the extensive legal legacy that the Roman Empire left. You have to think the majority of the civil law across most of Europe dates its origins to the Roman Empire and to the Roman legal system. And just like how the Romans exported things like Christianity across most of Europe, they so too also exported a lot of legal traditions across many parts of Europe. And now, the reason why we're going to be spending more of our time focusing on Anglo-Saxon influences over the development of the common law and not as much time looking at the Roman law specifically is because the Roman law didn't directly form the basis of the English common law, unlike the direct principles that we see in the majority of the civil law traditions in Europe. The Roman law didn't sort of take hold and capture the kind of foundations that it did across Europe. Okay, that doesn't mean there was no influence whatsoever. There are still little bits of influence that we can see when looking at the Roman law and the influence of Roman law on the English legal system. But for the most part, we can't see necessarily a clear connection from the common law, from the Roman law to the common law, if that makes sense. There are like little bits of influence, but it didn't take hold in the same kind of way that the Roman law did across in Europe. So let's just think about the Roman legal system in Britain. Roman law generally was formalized and a codified system, okay? This is a really important point. We will study Roman law in the future as its own separate series of lessons. But one of the things that we see was that the Roman law was primarily used to govern Roman citizens and soldiers that were stationed in Britain. Okay, so in the same way that they would control Roman citizens across other parts of Europe, they also would control parts of Britain. The provinces of the empire, including Britain, operated under a dual system of legal tradition. You have firstly the Roman civil law, okay, and the Roman civil law would apply to Roman citizens. It included things like property laws, personal rights, contracts as well. You also then have the provincial Roman law. The provincial Roman law would apply to the native population. So the system of law that was applicable when the Romans had control of Britain was a system of law which was divided among the civil tradition, the civil law itself, which applied to Roman citizens that were stationed in Britain, and then the provincial law, which would apply to native populations. This was a little bit less codified, a little bit less formalized, and that's one of the reasons why, when the Romans eventually leave Britain and we start to see the Anglo-Saxons, the Angles and the Saxons start to colonize and start to take hold of the British Isles, we see that the Roman law itself that did not survive in the same kind of way that it did in places like across Europe and whatnot. So essentially, the presence of Roman law in Britain did bring about more organized governance, and of course brought about legal systems in certain areas, in the same kind of way that it did across a lot of the Roman Empire. Towns had Roman-style courts. They handled legal disputes. They had Roman magistrates that administered justice according to the basic principles of Roman law. But for the most part, and for the majority of the native population, particularly when it comes to rural areas, which was the vast majority of Britain at the time, there was just the following of local customary laws. So the Roman law didn't really have the kind of in-depth influence over the majority of the population, the majority of the native population. During the Roman occupation, several important legal concepts were still nevertheless introduced. So the Roman law was codified. It was written down, unlike the sort of customary laws and traditions that existed within the rural areas of English society. A significant shift we see, obviously, from the sort of oral customary law of the native Britons. The Roman system of courts and legal officials, such as judges and magistrates, would eventually come to influence the development of a more formalized legal institution in Britain. So that's one of the things that we can sort of take from the Roman legal system as being influential from all the way back in the history of English law. Roman property law also was quite influential, including things like the idea of dominion, brought about more structured land tenure systems. And the Roman practice of issuing land titles and legalized transactions also helped influence land laws even after the Romans withdrew. So, as I mentioned at the start of this lesson, the common law wasn't a direct descendant from a Roman legal system that sort of stayed and has quite a lot of significant influences. But you can still nevertheless see some significant influences that remains even to this day within the sort of English legal system that comes from the Roman tradition and from the Roman legal concepts. And that makes sense given the sort of 400 years of occupation that we see within Roman Britain. But it is really when the Romans leave and we see the Angles and the Saxons take over that we start to see a true codification of the English legal systems. But even in that sense, the inflection point of the Norman conquests leads to another set of developments of legal principles and legal systems with things like feudalism and the development of such a system in that regard. So essentially, what we can conclude is that the English legal system is something of an amalgamation of all of these different prior systems that existed, taking little bits from each one and developing it and making alternative points, making alternative reforms and making alternative little changes here and there. And this has certain influence in terms of why we should study the English legal system and why we should study the Roman law and the influence of Anglo-Saxon law. But it is quite unique compared to that of, for example, the United States, that has a significant point at which a legal system develops, which is, of course, with the American Revolution and the establishment of the Constitution. And the similar thing we can see when we look at the revolutions in Europe. And this is one of the reasons, in fact, why we don't have a constitution, whereas places like France and Germany and the United States do have a sort of codified constitution compared to ours, because our history is very different. And that's one of the things that I want to sort of just keep on drilling into people when we are thinking about this study of history and this study of legal history in future lessons' time. In this lesson, what I want to do is spend some time talking about the influence and, more importantly, the legacy of the Roman legal system on the English legal system and the sort of influence that was left when the Romans eventually leave Britain in 410 AD. We'll talk about the things that didn't remain, things that didn't stay as part of the sort of the withdrawal of the Roman legal, of the Romans generally, and the collapse of the Roman legal system there. But then we will talk about some of the things that did remain, okay? And some of these things aren't strictly legal, but then sort of morph into and have legal influences that you can still trace back to the Romans. And that's why it's very important that we do this area of study. we'll spend some more time essentially looking at the Roman law and the influence that the Roman law has on the English legal system, bearing in mind that when we are talking about the development of the common law, we're only really going to be seeing this start to take shape more and more and more and more and more when we start looking at the post-Norman conquest, and we start looking at Henry II, for example. So the Anglo-Saxon system and the Roman law system provides something of a sort of precursor to the ways in which legal systems start to develop, whereas, as I mentioned in the previous lesson, the English legal system, if you study its history, is a study of various different institutions, various different legal systems, from the Romans to the Anglo-Saxons to the sort of to the Norman conquest, and then the development into that all have taken, and that all have different bits that remain and bits that eventually get thrown by the wayside, and there are bits that come back and get revived, and all this kind of thing. So it's like a strange mixing pot, a strange amalgamation of a variety of different legal principles, given the fact that there was a variety of different peoples who essentially lived in Britain and occupied Britain and basically controlled Britain. So we're going to talk in this lesson about the Roman law traditions that left, that remained, should I say, when the Romans left in 410 AD. And this really speaks more to the legacy of the Roman law. So the point that we can make straight away is that when the Roman legions did leave Britain in 410 AD, much of the Roman administrative and legal structures would collapse, and we see the collapsing of those institutions. And so what follows is the sort of Anglo-Saxon period, and what they essentially implemented within their system, we'll get to in more detail in future lessons, but they generally implemented, should I say, a reversion of localized customary laws. But there were still, nevertheless, certain Roman legal practices which would persist. And this makes sense given that for nearly 400 years, the Romans controlled much of Britain. And we noted in the previous lesson that one of the things that the Romans, or at least the Roman law, didn't do was penetrate all the way to every single facet of Britain. So, for example, they didn't they didn't essentially have the kind of structured administrative procedures that existed under the Roman law in all parts of the country, like places where there are rural farming and all that kind of parts. Those still remained very much using oral customary practices to operate their legal systems, essentially. So the Anglo-Saxons basically reverted back to this system, a system that existed prior to the Romans, but they still nevertheless allowed for and continued the practice of certain legal principles that did derive from the Romans. So in urban areas, specifically within towns and communities, there was, for example, the use of Latin, the continued use of Latin, and the preservation of Roman legal texts. Another thing that's important to note is that despite the collapse of the Romans' political control, certain administrative and legal institutions, such as the use of written documentation, did survive in some form. And this was in two particular contexts specifically, so within the church, within religious institutions, and also within commercial contexts. And this is one of the things that I wanted to mention when thinking about the legacy of the Roman law and the legacy that was left on the English legal system, and that's the influence of religion. The Romans, as I mentioned, exported Christianity across the empire. And the reason why that's so important is Christianity and the Christian church, the Catholic Church, begins to develop its own legal system. Okay, this becomes known as canon law, and the canon law would operate its own legal system where they would almost run alongside certain legal systems that existed in Europe and existed in Britain. And so that's one of the most powerful institutions that was left after the Roman withdrawal. And even though it's not directly to do with the law, the Christian church, it develops into its own legal system. And its own legal system that heavily influences the legal system that we see in the Anglo-Saxon period and that we see in the post-Norman conquests. And so the church maintained a legal system that was influenced by Roman principles. Things like the ecclesiastical legal tradition that would eventually have a strong influence on the development of law in medieval England. Another thing that should be noted, and that's very important, is the rediscovery of various principles. So the more profound and direct Roman influence on the common law would come during the 12th century and later, as Roman law was rediscovered and studied more in medieval Europe, just like how when we see the rediscovery of some of the classical philosophers within the world of ancient Greece, people like Aristotle and Plato sort of gets rediscovered, and that then gets sort of morphed into and wrapped up in the Christian doctrines of medieval Europe. And also, if we think about the Islamic Golden Age, a similar thing happens where we see the sort of ancient Greek philosophers start to be amalgamated into Islamic philosophy and into Christian philosophy. The period that I'm mentioning here saw the rise of universities, particularly in places like Italy and France, where Roman legal texts were studied. So people like Emperor Justinian's Corpus Juris Civilis was studied, it was analysed, it was taught as a part of an emerging field of legal scholarship. This was compiled, the Corpus Juris Civilis, in the 6th century by Justinian I, the Byzantine emperor, and was codified. Was a codification, should I say, of centuries of Roman legal thought. One of the things I want to just quickly mention for those of you who aren't familiar with the history, but the Roman Empire sort of exists in two distinct parts. You sort of have the Roman Empire in the West, which is the sort of Roman Empire that we know of and that we think about. But then we see a shift of the Roman Empire moving all the way to the east. The Eastern Roman Empire, sometimes known as the Byzantine Empire or Byzantium. This carries on until the sort of mid 1400s when it is taken over by the Ottomans. It was Emperor Constantine that founds Constantinople, modern day Istanbul. And so the Roman influence goes all the way up until the 1400s. And that's why you can see and understand that the Roman law is still very influential in Europe, especially to this day. The collection of Roman laws that we see in the Corpus Juris Civilis, particularly legal principles and scholarly commentary, have a significant impact on the development of legal systems across the Middle Ages. And that's where we get the civil law. For many European countries, France, Spain, Italy, there is legal systems that are adopted on the basis of the Roman civil law. This tradition sees a number of things, okay? So the codification of laws, written statutes, the application of general legal principles. And although England did not adopt the civil law, the Roman civil law, as fully as other parts of Europe, this is still important when we think about the study of Roman legal traditions and the development of English legal scholarship. Legal scholars in England would study the Roman law as a way to sort of integrate their understanding of the common law. And this is one of the things that's quite interesting. We see a quite significant division between the civil law traditions of the continental European countries, places like France, Spain, and Italy, and the sort of common law traditions of England and Wales. And this distinction is based partly on history. It's based partly on the fact that England has a very different history to that of the majority of the rest of England. The rest of Europe, should I say. But it's also partly due to the fact that the Romans were much more heavily entrenched in continental Europe than they were in Britain. There was sort of expedition in Britain, and then for the most part, the Romans would spend most of their time in continental Europe, and would remain as part of continental Europe all the way up until the collapse of the Byzantine Empire, the collapse of Constantinople to the Ottomans, all the way up into the 1400s. So that's another reason why we think about the Roman law in relation to our studies of the history of the English legal system. Now, as I've mentioned in the previous lesson, and as I will continue to mention when thinking about the influence of the Roman law, this first chapter talking about the Romans and the Anglo-Saxons, okay, is supposed to be a sort of preliminary foundational understanding of these two kinds of systems that, while didn't directly translate into post-Norman conquest and directly translate into the creation of the common law under Henry II, still influenced to a great extent a number of different parts of the legal system that we know of today. In this final lesson, looking at the influence of the Roman law on the development of the English legal system, I just want to think a little bit about the kind of things that are sort of left as a result of the Roman law and that still influences the common law to this very day. And this is including not only just legal principles or legal institutions, but just things like special words, specific words to describe specific things that sort of date back to the Roman law traditions. And this is just to sort of tie up all the things that we have been speaking about over the last few lessons, looking at the way in which the Roman law has been able to slowly develop into what we see today with the common law, and just to really reiterate the point that I made very early on, that we have a number of different layers of ideas, if you will, when it comes to sort of the kinds of things that the Roman law brought to the English legal system, the kind of things that the sort of Anglo-Saxons brings to the English legal system, and then when we start to think about the ways in which the English legal system starts to develop even more and more into the creation of the common law as we know it under Henry II. So, again, mentioning it very, very clearly, we know that while the common law, the English common law, remained distinct from Roman law since the Romans left, essentially, in 410 AD, several key Roman legal concepts and methods still influences its development, particularly when we think about the 12th century and beyond. We'll look at these principles in this lesson in more detail. So, let's begin first by thinking about legal procedures which were influenced by the Roman law. Well, the Roman law provided, as we know, a model for structured legal procedures and formalized judicial processes. Although the common law courts developed their own procedures and have their own influences from a variety of different places, this still nevertheless includes the Roman law. They were influenced by the Roman approaches to things like adjudication, especially when it comes to an emphasis that is placed on the nature of reasoned judgment, as well as the separation of legal issues into distinct questions. This is a kind of conceptual idea, and a conceptual analysis that is not necessarily specific legal principles, but is still nevertheless an important part, an important aspect of the creation of and the development of the Roman legal system. Now, many legal terms and concepts in the English law were derived from the Roman law, which is another area in which we can think about the creation of or the development of the English legal system and the way in which the Roman law comes at that approach. So the Roman concept of persona, for example, the idea of a legal person, influences the development of ideas about legal capacity in English law. The idea of stare decisis, is a Roman legal principle that translates from Latin to mean to stand by things decided. While developed in the common law as its own separate principle, it still nevertheless bears a quite significant resemblance to the Roman practice of respecting precedent and constituent rulings. Remember, for those of you who have studied the English legal system and have studied the way in which the English legal system operates, one of the things that's important is this idea of stare decisis. And it's something that is exported across a lot of the common law world. Stare decisis is an important part of, for example, the legal system in the United States. And so all of these things derive from the basic principle in law, the basic principle in Roman law, to stand by things decided. The idea of the law of obligations, which is an area of English law which concerns things like contracts, consensual agreements, sales and loans, for example, all begin their life and were influenced by the Roman law itself. Formation of contract law in England through common law, we see it take more case-based approach to contractual disputes. Another area where we see quite a significant amount of influence is when we look at the legacy of property law from the Roman law tradition. Roman law had a significant influence over the way in which property was adjudicated. The Roman concept, for example, of dominion, which referred to the absolute ownership of property, helped to shape the nature of a variety of different English land law traditions, such as, for example, the nature of land ownership, the idea of tenure, and the nature of transfer. In addition to this, we see the Roman distinction between real property, i.e. realty and land, and personal property, i.e. movable goods, becoming an integral part of English property law. For those of you who haven't studied our lesson on land law, our lessons, should I say, plural, on land law, you'll notice that this is a similarity that we can see between these different principles as well. Another very important part of the English legal system that we will spend time thinking about on its own is also this principle of equity, the idea of equity, beginning within the Roman law. Again, the Roman law included the concept of what was known as equitas, or equity, which emphasized the nature of fairness and the nature of justice within legal decisions. This development leads to the influence of, and the influence by, the English Court of Chancery. The English Court of Chancery was a system of law which would essentially provide remedies that were in equity that the common law did not. So in situations where the common law was seen as particularly rigid and particularly unjust in the application, where the application of the common law is still correct, but it still nevertheless is quite unjust, the Court of Chancery can step in and apply principles of equity that would emphasize fairness and justice. We then see in the 1870s the Judicature Act, which sort of merges the courts of Chancery with the rest of the common law and merges the common law and the law of equity together. But for the majority of the English legal system, you have a sort of duality that exists between the Court of Chancery on the one hand and the courts of the common law on the other. And there are various instances and situations where these actually clash with each other in a variety of different ways. So this is another example of how this actually operates. Furthermore, the Roman natural law theory, from a jurisprudential standpoint, which suggested that law should be based on reason and universal principles of justice, would eventually start to influence English legal philosophy. So not only from the actual strict application of the law, but also when it comes to the ways in which jurisprudence was operated and legal philosophy was sort of developed as well. And of course, natural law theory takes a lot of inspiration as well subsequently when we think also about the nature of the nature of Christianity and the influence of religion and Christianity in relation to that as well. So even though I've been saying for the past sort of like 4 or 5 lessons that the Roman law has little hints of influence over the English legal system, there are still nevertheless very important principles that have their origins in Roman traditions that you should still be familiar with when we start to now move on and think about the ways in which we see the development of the Anglo-Saxon legal system, which we're going to spend even more time thinking about in future lessons.